What's that?
Are you going to allow
No, I'm
me?
talking to you. Why are you taking her out?
No.
You're not? Okay.
Because I don't want to be in here. I
Stay in.
requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. All right, stand by. Apparently they're going to restrain her and bring her back in.
Started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national as defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond.
Our advisory council is here. Mr. Wagner, are you appearing before the state?
Yes.
This is the time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now. Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C, ARA...
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count 3, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why are they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis, by the way. Turn it on.
Excuse me, that's illegal. Y'all can't
All right.
do that.
No, that's on now. Turn it on.
Yes, it is, Justice.
All right. So the offenses are non-dangerous. I'm finding them
Why are you allowing that?
I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor. She's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, And she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me, y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes.
Talking about the fall.
She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to.
All right, thank you.
So if there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count...
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up?
No.
You're not? Okay.
Because I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
All right, stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing up in the legal The court lacks jurisdiction over the subject matter. Y'all don't have no right. Get this shit off of me.
If I could have just a second, Your Honor.
I ain't never been fighting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-708?
Yes, I'm sorry, ARS 13-708.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victim's presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count one, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count one, Class 5 felony, is 3.5 years. As to count two, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count four, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the second degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. This court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count four is 5.5 years. As to count five, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years for a total of 3 years as to count five. The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for her arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the costs of an attorney to represent you on appeal. That will include the costs of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay.
You said I need what with that?
You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much
What?
time?
Hold on a second. What?
How much time did you give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you all.
Good afternoon, Mr. Peltola. Can you hear me adequately?
Yes, I can, Honor. How are you doing?
Good, thank you. How are you today?
Not too bad. Feeling a little rough, sore from being in a holding cell 3 days, but other than that, I'm okay.
All right, let me call your matter so we're on the record, please. People of the state of Michigan versus Drew James Peltola, 247819 SM. Mr. Peltola appears from the Dickinson County Jail. Counsel at first appearance is Abby Anderson, who appears via video Zoom. And the prosecution is not here today of their own choosing. Mr. Peltola, before we went on the record, indicated he could hear me adequately and he was all right other than being sore from being in the holding cell for 3 days. In respect to the matter then, Mr. Peltola, I do have an advice of rights here with your signature. I do see it looks like the copyright insignia. I know that we have discussed the issue of the sovereign citizen in the past. Mr. Peltola, can you tell me what your position is today, please? After telling me what your full legal name is, if you would.
Okay, I'm appellation known as all capital letters Drew James Peltola with a common law copyright as a sui juris human as a non-citizen, a not American national. That's defined in the United States Code. I'd like to have my lawyer finish talking. She told me not to talk unless she could talk first.
All right, thank you. Go ahead, Ms. Anderson.
Thank you, Your Honor. I have discussed these matters with Mr. Peltola. First, he agrees to be referred to as Mr. Peltola for purposes of these hearings. We have gone over both the advice of rights for misdemeanor and bond violation. He indicated he understood and signed both. As to the allegations, we went over the maximum penalties. We would waive the formal reading. He is tendering not guilty pleas and requested an attorney. Ms. Mashik-Lasala has assigned Nancy Schaub to represent him.
All right, very well. As indicated by Ms. Anderson, Mr. Peltola has agreed for purposes of his criminal prosecution to be referred to as Drew James Peltola. His position in respect to how he should be recognized legally has been stated for the record and is preserved for the record, as well as stated on the advice of rights form concerning both the general misdemeanor advice of rights. Although the bond violation advice of rights doesn't so indicate, the court will recognize his position for purposes of both advice of rights. Concerning the matter then, is this a good mailing address for you, Mr. Peltola, on River Street in Niagara?
Yes, Your Honor. I'm just trying to move back into Michigan. So I've been working and that's the address that I use because that's my domicile. I always return to every day or once a week or whatever. Because the Michigan residents, I'm not even sure. I would not like to talk about that in court, but I'm trying to move back into Michigan. I'm just having a heck of a time doing it.
All right. So this is what I'm going to do then, Mr. Peltola. Over there, let's see if I have one in my file first. Ms. Anderson, I don't see a waiver of extradition. It sounds like he's going to need to go back and forth to Wisconsin, and we'll address that momentarily. In respect to the matter, though, Mr. Peltola, there is a waiver of extradition form over there at the jail. I'm going to have you sign that if you need to go into Wisconsin as part of this. In regard to the
Honor.
matter, then, what?
How do you want me to sign this? If you want my copyright, do you want me sui juris, just so you understand, like I wasn't trying to harm you or any other woman?
Go ahead.
Do
What?
you want my copyright on this? Do you want me as a human or me as a sui juris non-citizen national?
I just want your signature and the date, and whatever you want to put in addition to that is fine with me.
All right, thank you. Can I have a pen?
Your Honor, while Mr. Peltola is signing that, we did discuss the waiver of extradition. He just wanted that answer clarified prior to signing, but he is aware of what the waiver of extradition is.
Very good, thank you. All right, I'll enter not guilty pleas on behalf of Mr. Peltola. Ms. Anderson indicates that he's qualified and he is being assigned by MIDC. Ms. Schaub, we're going to set bond violation hearing. We might as well do the pretrial at the same time. And a jury trial as follows.
Do you want the jury trial within 20?
Yes, just to be safe.
Okay. Pretrial conference and bond violation hearing on February 21st at 1:45 p.m. Jury trial, March 8th at 9 a.m.
All right, you'll get these dates in writing, Mr. Peltola. In respect to the waiver of extradition, then I want to go over it with you briefly as well.
All right, cool.
In
I can wait.
respect-
You want me to stop filling this out?
Really, all you need to do, yeah, go ahead. You finish, and then I'll go, and then I'll talk. You let me know when you're ready.
I'll just sign it real quick on the bottom of it, and they can take care of the rest of it. I'll sign it properly. The bottom law might be wrong. It's been a while since I've read the Unified Court, but I believe this is right. I signed it for you correctly. So.
All right, perfect. All right, if you give that to the jailer, Mr. Peltola, I want to go over with you what it means to sign that waiver. I know we've done this before, but I'll just refresh your memory. And let me start by saying, so long as you come back to court voluntarily for all your court appearances, this does not become relevant. But if you don't come back to court, let's say, for example, you stayed in Niagara or somewhere else like that, normally you're entitled to what's called an extradition hearing before you are returned to Michigan to fight the charges that you didn't come back to court for. Yes. Under an extradition hearing umbrella, you have the right to an open court hearing. You have the right to have a lawyer at that hearing. And if you're indigent or without funds, one is assigned for you. The purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan. For example, you could demand issuance and service of a Michigan governor's warrant for your arrest. You have the right to obtain a writ of habeas corpus. Like I said, all to challenge the legality of your arrest and return to Michigan. When you sign a waiver, what?
I said I won't resist, man.
I'm just explaining to you what that document is that you're signing, okay, for the record. That's all. I'm not suggesting, implying, or anything else. I'm just explaining, all right?
Thank you.
All right. So when you sign that waiver, then what that means is, and like I said to start with, so long as you come back to court, everything is hunky-dory or everything is all right. But if you don't come back, when you sign that waiver, you have given up your right to that type of a hearing that I just explained. Do you understand that?
Yes, Your Honor.
All right. So that's what that means. So when I'm setting bond, I need that form back because I'm going to do the following in respect to your bond. And this can cover both the bond violation and the underlying charge of disorderly. All right, first off, you must sign a waiver of extradition as a condition of your bond. So long as you do, you can go back and forth between Michigan and Wisconsin for residency, court appearances, family visitation. If it expands beyond that, talk to your lawyer first, okay?
Yes, Your Honor.
All right, you are not to purchase, possess, or consume alcohol or non-prescribed controlled substances. You must submit to random PBTs and drug screens as a condition of your release. Don't go into businesses that sell alcohol for use inside, such as bars and taverns. Do not engage in any assaultive, threatening, harassing, or intimidating behavior towards any person while you are on bond. All right, so you are in one of those unique positions, Mr. Peltola, where you have come before the court for your arraignment. Already behind you, or what you're being arraigned on, is both the underlying charge and a bond violation. So usually people will have an underlying charge and then whatever, week 2, 3 later, they come back with the bond violation. And when people are arraigned, I always give them a talk and tell them that if you come back with a bond violation, you're going to make it really hard for me to say, gee, I should let you back out into the community again. You, however, have not had that talk. You are having it today, and you are having it on both the underlying charge and the bond violation. So my pep talk is this, Mr. Peltola, I'm going to set the bond accordingly and give you the benefit of the doubt. But if you come back in here with another violation, I'm going to say, gee, Mr. Peltola, I had the talk with you and you went out and did the same thing I told you not to do. So I'm telling you, don't violate your bond and make me have a reason to keep you in custody pending resolution of your case. I'll set your bond right now at 1,000 PR. That's on both the bond violation and the underlying charge. They're going to let you back out, Mr. Peltola. Don't go back out and start drinking and do this again because, like I said, you'll leave me no choice. All right?
Oh, Your Honor, honest to God, I'm not even on drugs anymore. I wasn't sick. The only reason.
Hold on.
Nope.
I can see Miss Anderson almost doing cartwheels back there. She does not want you to talk until you have a chance to talk to your lawyer. Is that right, Miss Anderson?
That is correct, Your Honor. Thank you.
All right, Mr. Peltola, do you understand? She wants you to talk to your lawyer before you tell me anything, all right?
Yes, I understand, Ms. Lacoste, or Judge Lacoste.
Thank you, Mr. Peltola. We will see you soon. Your bond will come over, your writing dates, your lawyers. Make sure you call her when you get out and, you know, have a meeting with her. All right, Mr. Peltola?
Yes, Your Honor.
All right, anything else on this file then, Miss Anderson?
No, thank you, Your Honor.
All right, thank you. Have a good day, Mr. Peltola.
You as well.
Thank you. Again, versus Drew James Peltola, files 247831 SM and file 247819 SM. Mr. Peltola appears from the Dickinson County Jail. Counsel
Appellation known as Drew James Peltola appears before you as an entity.
Hold on a minute. Just let me make the appearances, and I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 247819 SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file, as well as a new file of 7831 SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
Ma'am, I was trying to get a ride to court this morning. This bond violation.
Wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being.
All right. Is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off the drugs and try to maintain my court dates.
All right. In regard to the matter then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, your objections in respect to the court's jurisdiction and whatnot are noted for the record. All right, concerning the matter, then I have some concerns regarding Mr. Peltola. He seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between, they get arraigned, I give them the warning, and then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw them all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation, as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then, for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time. And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case. Total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being, for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as now here. In regard to the matter, Mr. Peltola, I'm going to address.
Every court weighs credibility, not just claims. Behavioral research shows that repeated choices become stronger predictors than promises. Sovereign citizen arguments may challenge jurisdiction, but they do not erase a pattern of conduct. Once prior warnings are followed by another alleged violation, the court's focus naturally shifts from trust to managing future risk.
You to talk to your lawyer. I'm setting bond. Concerning the new theft case, then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his attorney. If
in residency, he lives in Wisconsin.
in residency. No, he lives in Vulcan. Or he says Vulcan. Is that just your
Bracketed.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My residency and my domicile is 1968 River Street. We can switch it with a mailing address to W43, the apartment 13 in Vulcan, Michigan. The address should be in there. It should be bracketed.
Right, and that's apartment 13. You didn't put that on there though. Apartment 13?
Yes, ma'am.
And that's your mailing address though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got two issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your mother's house is, Mr. Peltola.
Address.
River Street, Niagara, Wisconsin, 54151. My mailing address will be W45. That's the Norway to the Vulcan address. I can't remember that off the top of my head.
All right. So in regard to bond, then condition on him signing a waiver of extradition, I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. At 1,000 cash surety, 10%. In regard to the newest bond violation, then I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release him on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at 2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in custody, she'll be in touch with you. You may.
Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond. Especially today, when I was arrested on a larceny under $200, somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
All right, Mr. Peltola, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your.
Can I at least tell you, admit I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence? Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
Although these hearings involve different defendants and different charges, they reveal the same legal pattern. Courts are not deciding whether someone sounds confident, determined, or unconventional. They are deciding whether the record supports accountability under the law. In both cases, arguments commonly associated with the sovereign citizen movement, claims about jurisdiction, legal identity, copyrighting a name, or being an American national, never replace the evidence the courts were required to consider. The judges repeatedly returned to the same questions. Were prior court orders followed? Were release conditions obeyed? What does the documented record show? That difference matters. Sovereign citizen theories often encourage people to believe that changing legal language changes legal obligations. Courtrooms operate in the opposite direction. Judges rely on statutes, procedure, prior rulings, and documented conduct rather than personal interpretations of authority. When someone continues relying on arguments the court has already rejected, attention shifts away from the legal theory itself and toward whether the person's decisions increase legal risk. Another common thread is that consequences rarely come from one moment alone. They build over time. Every missed opportunity to work through established legal procedures narrows future options. Every ignored warning gives the court additional reasons to impose stricter conditions or longer consequences where authorized by law. By the time sentencing or bond decisions arrive, judges are often evaluating an entire pattern rather than a single exchange. These hearings are a reminder that courtroom outcomes are usually shaped less by the words people choose and more by the decisions they repeatedly make before, during, and after entering the courtroom. The legal arguments may differ from case to case, but the relationship between choices and consequences remains remarkably consistent.